Hi guys, good evening. I hope I'm perfectly live right now. Welcome to the session. Hi Anisha, hello Vaishnavi, welcome to the class. How are you all? Okay, let me just look at the chat window. Yes, I am properly live and yeah, chalo. And I welcome all of you to this very important lesson 18th lesson on the complete course on Constitution of India. We are doing this series and we are done with 17 lessons. So this is our 18th lesson. Today we are going to talk about amendment to the Indian Constitution. So is how can a constitution or how can Indian Constitution be amended? What is the procedure? What is the power of amendment? Who can amend the Constitution? And we're going to understand all of these things in today's class. So before getting into that, let me just run you through very quick updates which are there over here. Yeah. Hi Kavya, welcome to the class. How are you? Yeah. So we have already extended the Unacademy Unlock 20 discounts till 19th of February, that is today, till midnight. If you are subscribing to Unacademy Plus or Iconic by using my code Thrinath10 THRINATH10, you will be able to get additional 20% discount on all Unacademy subscriptions. This is applicable in CLAT, Judiciary, UPPSC, UPSC, and all the other categories which are there on the Unacademy Learners application. And then I'm also launching weekend challenger series for law aspirants on today and also tomorrow, 19th and 20th of February at 7 p.m. we'll be having legal reasoning test, and at 7:30 p.m. we'll be having current affairs and GK ka test. So in order to enroll in this particular exam, or in order to enroll in this particular test series, you can use my code Thrinath10 THRINATH10. Tomorrow I'm launching championship mock test for CLAT 2022 and also for CLAT 2023. First ranker is going to get Amazon voucher worth rupees 5,000. Second ranker is going to get Amazon voucher worth rupees 3,000, and third ranker is going to get Amazon voucher worth rupees 2,000. Happening tomorrow, Sunday, 20th February at 12 p.m. Use my code Thrinath10 THRINATH10 to unlock this particular test absolutely for free. Very less strength in the class today. Please share this particular link in the Telegram group and also inform them that I am live right now. Okay. And if you want to subscribe to Unacademy Plus in the CLAT and the 5 LLB exam, North 10 is the code, and the Unacademy subscriptions link is there in the description. You can go there and check it out. Okay, so without any further ado, let's get into our business of understanding what exactly is the amendment process. Now, what do you mean by amendment? Amendment simply means any change. So just like any other written constitution in the world, Indian constitution also provides for its amendment in order to adjust according to the changing conditions and needs. See, now we have drafted this constitution very old, that is in the year 1949, and this came into force in 1950. And there have been a lot of changes which are coming up in the society, and we have to adjust ourselves to that. So for that, we need some changes in the constitution, and we have already made some changes. And how to make any change in the Indian constitution, we are going to learn it in today's class. So, who is empowered to amend the constitution? So, the answer is here. Article 368 in part 20 of the Indian constitution deals with the power of parliament to amend the constitution and its procedure, which means that parliament is a competent authority to amend any part of the Indian constitution. And this power, the parliament derives it from Article 368, which is in part 20 of the Indian constitution. Parts are always written in Roman. Okay. And it states that parliament may amend the constitution by way of addition, variation, or repeal any provision in accordance with the procedure laid down for the purpose. Now, what are the various ways of amending the constitution? First thing is by addition. What do I mean by addition? Addition means you are adding a different provision. Let us say Article 21A was added by 86th Constitutional Amendment Act of 2002. And second one is variation. So variation means that you are changing something. You're not. It is a kind of addition and revision. It is you are actually changing something. The same 86th Amendment changed before that, right to education was a DPSP. It was changed to a fundamental right. That is variation. You are making some change. And third one is repeal. So repeal means you are completely removing that particular provision. Let us say right to property, it was removed or it was repealed as a fundamental right. It was placed as a legal right under Article 300 capital A. So how can Parliament do this? It is in accordance with the procedure laid down for the purpose. So for different provisions, there are different procedures. We are going to understand those procedures in the later part of this class. However, the Parliament cannot amend those provisions which form the basic structure of the Indian Constitution. Basic structure is our next chapter. So as I told you in my previous classes that in Keshwan and the Bharati versus State of Kerala, Supreme Court held that certain features are basic features or they are basic structure, and Parliament cannot take away basic structure. Basic structure is a bedrock and it cannot be taken away by Parliament even by a constitutional amendment. So I hope this is clear for everyone. Please give me a very quick yes or no in the chat window. I hope this is clear. Please hit the like button if you are understanding this particular session. And then there are three types of amendments in the Indian Constitution. Instead of three types, there are three ways in which the Constitution can be amended. First one is amendment by simple majority of Parliament. So what is simple majority? Simple majority is 50% plus 1 present and voting. If there are 100 members who are present, out of that 51 has to accept this particular thing, we can make an amendment. Okay. Then amendment by special majority of Parliament. So what exactly is special majority? We are going to understand in the next slides. And third type of amendment is amendment by special majority of Parliament plus, along with the special majority of Parliament, we require ratification of at least half of the state legislatures. After Parliament has enacted this particular amendment, the states, at least half of the states, has to approve this particular thing. So these are three ways in which Indian Constitution can be amended. No response in the chat window. Why is that? I don't know. So if please give me very quick yes or no in the chat window so that I can understand you guys are following this thing. Now let us understand, point by point. So what are the provisions that can be amended by simple majority? What are the provisions that requires a special majority of Parliament, and what are the provisions that require special majority of Parliament and ratification of half of the state legislature? First one, by simple majority. Simple majority, as I told you, 50% plus 1 present and voting, not the total strength, present and voting. First one is admission or establishment of new states, as we have discussed under Article 2 of the Indian Constitution. Then formation of new states, alteration of areas, boundaries or names of existing states, which is dealt under Article 3. And then abolition or creation of legislative councils in the states. Then second schedule emoluments, if you want to change the salaries of president, vice president or speaker of Lok Sabha and all of these things, then you can do it by a simple majority of Parliament. Then if you want to amend the allowances and privileges and so on of president, governors and speakers, then it requires a simple majority. Then salaries and allowances of members of Parliament, rules of procedure in Parliament, privileges of the Parliament, its members and also parliamentary committees, and usage of English language in the Parliament. All of these require a simple majority. And along with these, there are some other things. Very good Vaishnavi, Madhulika and Amita. Number of puisne judges in the Supreme Court. What do I mean by puisne judges? Puisne judges are the judges other than the Chief Justice. In High Court and also in the Supreme Court. In Supreme Court, we have Chief Justice and other judges. The other judges are known as puisne judges. And then conferment of more jurisdiction on the Supreme Court. I'm sorry, this is a small typo. So here again conferment of more jurisdiction on the High Courts. So instead of High Courts, I wrote, I did again. So now what is this conferment of more jurisdiction? So you know that as of now, just give me a second. Yeah. So conferment of more jurisdiction means that if you want to increase the powers of Supreme Court, you cannot reduce the powers of Supreme Court. Yes, exactly. Yes, Vaishnavi, we have discussed that in the previous class, in our beginning classes, right? Yeah. So if you want to increase the power of Supreme Court, jurisdiction doesn't mean only territorial jurisdiction. It includes pecuniary jurisdiction and the entire power. So if you want to increase the power of Supreme Court and also the power of High Courts, then you have to do it by a simple majority. And then citizenship, acquisition and termination under Article 11 of the Indian Constitution, Parliament is empowered to do that. Elections to Parliament and state legislature, simple majority. Delimitation of constituencies, Don't worry if you don't understand what is delimitation. In our upcoming chapters on parliament, we are going to understand what exactly is delimitation. Then anything with respect to union territories and anything with respect to fifth and sixth schedule areas, this requires a simple majority. And this list is not exhaustive, but it is illustrative. And in a lot of other provisions, these are a lot of other provisions which are simple in nature. They can be amended by simple majority of parliament. This is the first thing. And then before getting into that, I just want to tell you, if any change is made by using simple majority, it does not affect the constitution. Now let us say if a new state is formed. If a new state is formed, it is not going to alter any number in the Indian constitution. Rather, it adds one more state in the first schedule. It changes fourth schedule. But there is no prime or a very big change in the Indian constitution. All of these provisions, if you're making any change to all of these things, they are not going to affect the constitution in any way. We are not going to change the text of the constitution. Okay. Now, and the best example is that the best example I'll tell you now, conferment of more jurisdiction. If the number of purist judges in the Supreme Court under Article 124 of the Indian Constitution, the Supreme Court, the Constitution says that Supreme Court consists of Chief Justice and 7 other judges. But now the total number of judges are 34. Even if they now the number is 34, but the number is not changed in the Indian Constitution. It is just a 7. We have just increased the number by special majority. Madhulika, if you are having a basic understanding of these things, that will be sufficient. But you will understand, even if you're not getting it by heart, you'll be able to understand, like if you are, well versed with the constitution. That will not be a problem. But please make sure that you are remembering these things, that, matters which are of like less serious in nature, they will be requiring simple majority. Okay. Then, by special majority of parliament, what do I mean by special majority of parliament? Please pay very close attention here. The majority of provisions in the Indian constitution need to be amended by a special majority of parliament. What do I mean by special majority of parliament? First one, a majority of the total membership of each house. Now, what do I mean by that? What is the total membership of each house? Lok Sabha 545 is a total majority. Now, when I am counting total majority, you should actually take into account the vacant seats, members who are absent. All of these will be calculated. Okay, the total number is 545. In 545, there should be 50% plus, along with that, a majority of 2/3 of the members of each house present and voting. Again, now let us say there are 545 members and there are 300 members sitting in the parliament. Out of 300, more than 200 has to accept this one. Two conditions has to be fulfilled. First one is that there should be half of the total strength, that is half of 545, plus 2/3 of the members present and voting. If there are 300, then at least more than 200, or the minimum number is 201 people should vote for this particular thing. Okay. And other thing is that this 2/3 number, okay, this 2/3 should be more than 50% of the parliament, 50% of the total strength. And as I told you previously, that the expression total membership means the total number of members comprising the house, irrespective of the fact whether they are vacancies or absentees. Even though somebody is absent, somebody is vacant, we don't count it. The total strength will be taken into account. Is this clear for everyone? Please give me very quick yes or no in the chat window. Is this clear for everyone? Next, the special majority is required only for voting at the third reading stage of the bill, but by way of abundant caution, the requirement for special majority has been provided in the rules of the house in respect of all the effective stages of bill. Don't worry if you don't understand this point. So let me tell you something, that there are various stages of a bill: the first reading, second reading, and the third reading. So third reading is somewhere where the bill is put for vote. Here it says that the constitution stated special majority is required only at the time of voting. Okay, but in the rules of house, it is provided that at every stage, when the bill is introduced and when other members are speaking, there should be 2/3 members and also more than 50%. But generally, the thing is that voting is required. More than 50% plus 2/3. Both these categories are required. Then the provision can be amended. The provisions which can be amended by this way are like fundamental rights, DPSPs, and all the other provisions which are not covered by first and third category. First category we have already discussed, simple majority. Then we are also going to understand the third category, that is which requires ratification of half of the states. So we're going to discuss that. Okay. Vaishnavi did not understand. Okay, no problem, Vaishnavi. I know that it is a little confusion. So I think it would be better if I've used, the whiteboard, but now I don't have the chance of that. But don't just, let's keep it very simple. Now let Vaishnavi, you know that the total strength of Lok Sabha is, let us take the example of Lok Sabha. The rough strength will take it as 500. Okay. Now, out of these 500, there are two conditions. First condition is that out of 500, more than 50% has to be present. That is more than 250. Along with that, two-third of the members present and voting. Now, out of 500, let us say 400 are present. If 400 are present, then you require two-third majority. That means more than 200 again. And this two-third majority, the two-third number whichever is there, it should be greater than the 50% of the total strength. Now, let us say the 50% of the total strength is 200 as we are taking it as 400. If you are taking the total strength as 400, the 50% is 200. Then you should definitely have more than 200. And if let us say if 400 members are present, then the number of people who are voting, it should be two-thirds. That means it should be again more than let us say 250. Let me give you a rough idea over here. Now let me take the total strength as 500. 500 is the total strength. 500 is the total strength. Out of this, the first requirement is that 500 is the total strength, and let us say 300 members are present. 300 members are present. Now let us look at the condition. First condition is that 50%, more than 50%, which means the minimum strength that is required is 251. Okay. Second condition is that two-third of 300. Now two-third of 300 should be, what is two-third of 300? It is more than 200 plus again. Okay. Now this 200 plus this two-third of 300 should be greater. Okay, this should be greater than 50% of the total strength. 50% of the total strength. I hope you're getting this particular thing. Now, out of 300, how many members should be present if you want to cross this particular thing? At least 252 members has to vote. 252 members has to vote, in favor of the amendment. In favor of the amendment. Is this clear for you, Vaishnavi? Is this clear for you? Two conditions are required: total strength and also how many members are present. Out of total strength, 50% is required. Out of present strength, two-thirds is required. And this two-thirds should be greater than 50% of the total strength. Okay, is this clear for you? Chalo. Okay. Yeah, I'll zoom it, Madhulika, just wait. So what are these provisions? By special majority, fundamental rights, DPSP, and all other provisions which are not covered. Can you see this, guys? You can take a screenshot if you want, after this particular thing. It's not possible to zoom, I guess. Okay. So let us proceed with the next part. Okay, very good. Next one. Third type of majorities by special majority of parliament and consent of states. Now, what are these provisions? Earlier, we have discussed that, Article 368 says, Article 368 deals with the power of parliament to amend the constitution. Now, when parliament has a power to amend the constitution, why are these states coming in between? States are there because if any of the amendment is related to federal structure, then we have to take the consent of states. So these are, these provisions are those provisions of the constitution which are related to federal structure of the polity, and they can be amended by a special majority of parliament, which means this condition which I have told you. Along with this, the consent of half of the state legislatures by a simple majority. Okay. So what do you mean by that? States have to pass it with the simple majority, that is 50% plus one present and voting. If one or some or all the remaining states take no action on the bill, it does not matter. Okay, it does not matter. The moment half of the states give their consent, the formality is completed. Okay, I hope this is clear for everyone. We require the consent of half of the states. Now there are 28 states in India out of 28. Once 14 states gave their consent, the formality is completed. We are least bothered about the other 14 states which are yet to take action on this particular thing. Okay. And other thing is that there is no time limit within which the state should give their consent to the bill. So this is again a gray area, which sometimes might delay the bill. But as of now, this particular instance has not come yet. I hope this particular paragraph is clear for everyone. Please give me very quick yes or no in the chat window. And then what are the provisions which require an amendment in this way? First one is election of president and its manner. Second one is the extent of executive power of union and states. And third one is the Supreme Court and High Courts. Here, in the previous thing, a simple majority, we are actually increasing the jurisdiction of Supreme Court and High Court. But here, if you are making any other change other than increasing the power, okay, if you want to there is no chance of reducing the power, but for some provisions it require an amendment. Like let us say if you want to transfer the power of giving writs for ordinary law violation to the Supreme Court, then it might require a special majority. And then distribution of legislative power between union and state, a very important federal provision for which you require a special majority. And again, and any of the list in 7th schedule, because 7th schedule deals with the federal structure, because there are 3 lists. There is a division of powers between center and states. It also requires special majority and also consent of all the half of the states, and then representation of states in parliament, that and also power of parliament to amend the constitution and its procedure, that is article 368. If you want to make an amendment to article 368 itself, because 368 is also a part of the Indian constitution, if you want to make a change to it, then it requires special majority of the parliament and simple majority of half of the states. I hope this is clear for everyone. Is this clear for everyone? Give me yes or no in the chat window. And then what is the constitutional amendment process? Very important thing. Please pay very close attention here. Very close attention. The procedure for the amendment of the constitution as laid down in article 368 is as follows. First one, an amendment of the constitution can be initiated only by the introduction of a bill for that purpose in either of the house, that is either in Lok Sabha or Rajya Sabha, and not in state legislatures, which means first thing, bill can be introduced only in parliament, that is either Lok Sabha or Rajya Sabha. And second thing is that only by a bill in the parliament, which means that constitutional amendment cannot be done by promulgating an ordinance. Okay, don't worry if you don't understand what is ordinance. We are going to understand them when we are discussing the chapters of president and governor. So for the time being, remember that when the parliament is not in session, president promulgates an ordinance. When the state legislature is not in session, governor promulgates an ordinance. Constitutional amendment cannot be promulgated by ordinance. It requires the introduction of a bill in either Lok Sabha or Rajya Sabha. There might be a question in your examination. Constitutional amendment bill can be introduced in which of the following houses? A, Lok Sabha; B, Rajya Sabha; C, either of them; D, none of the above. So the answer is either of the above, either in Lok Sabha or in Rajya Sabha. Point number 1. Number 2, the bill can be introduced either by a minister or by a private member and does not require prior permission of the president. So you all understand who is a minister. A minister is somebody who is in the council of ministers. And what do I mean by private member? All the members in the house other than minister are considered as private members. He might be from the ruling party or he might be from the opposition party. All members other than a minister is a private member, and private members can also introduce constitutional amendment bill. Point number 2. Number 3, the bill must be passed in each house by a special majority, that is a majority which is more than 50%, and also two-thirds of the majority of present and voting. And this I have already discussed. And the first process, which is a simple majority, is an exception to this because it is not making any major change in the constitution. And then each house has to pass the bill separately, which means that there is no provision of joint sitting. Okay, please take a note of this one. There is no provision of joint sitting. Don't worry if you don't understand what is joint sitting. We are going to understand them when we are talking about the parliament chapter. So joint sitting cannot be there. Clear for everyone? No joint sitting. Each house has to pass the bill separately. Next, in case of disagreement between the two houses, there is no provision for holding a joint sitting, as I've already explained you. Why did I write it over here? Yeah. If the bill seeks to amend the federal provisions of the constitution, it requires, the ratification of states by a simple majority. And then, after a very important point, after duly passed by the houses of parliament and ratified by the state legislature where necessary, the bill is presented to the president for his assent. And please pay very close attention here. The president must give his assent to the bill. The president must give his assent to the bill. He can neither withhold his assent nor return the bill for reconsideration. Earlier, the president has the power. He can withhold the bill or he can return the bill for reconsideration. But the 24th Constitutional Amendment Act of 1971 made the president giving his assent mandatory. President cannot reject the bill. President cannot resend the bill for reconsideration. Please take a note of this. Then, after the president's assent, the bill becomes an act, that is a constitutional amendment act, and the constitution stands amended in accordance with the terms of the act. So this is how the amendment process takes place. President has to mandatorily give his assent. He has to sign it anyway. There is no provision of withholding or returning the bill for reconsideration. Clear for everyone? Is this clear for everyone? Please don't be mute spectators in the class. I want all of you to give response in the chat window. Then what is the scope of amendability? The present position is that under Article 368, any and every provision of the Constitution, including fundamental rights, can be amended, but without affecting basic structure. In Keshwananda Bharati case, in Keshwananda Bharati versus State of Kerala, Supreme Court said, Parliament can amend fundamental rights, Parliament can amend DPSP, UPSC, anything can be amended, but it should not affect the basic structure of the Constitution. What exactly is basic structure? What falls under basic structure? We are going to learn them in our next live class. Okay. So in the next live class, we'll be discussing most important amendments to the Constitution. And then in the next class, we'll be talking about basic structure. So please take a note of this. And okay, we'll talk about basic structure in the next class. And it's already 8 o'clock. So I'm ending this class right away. And please make sure that this is the last day to avail the Unlock 20 offer. If you want to take any of the subscriptions, the link is in the description. Go there and take your subscriptions. The code is already added. So with this note, I hope you've enjoyed this particular class. I'm looking forward to seeing you all in my classes tomorrow. And please make sure that you are liking this particular session. Do subscribe to this channel. If any of your friends is preparing for CLAT or LAWCET or any other law entrance exams in India, please do consider sharing this video to them and ask them to subscribe to this particular channel. And bye bye. I'll see you all in the next class.